Chancellor Carrington and Commissioners for Her Majesty's Revenue and Customs.
Yes. Good morning, my
Good morning.
lords. Good morning, my lords, my lady. I appear on behalf of Her Majesty's Revenue and Customs and Secretary for Work and Pensions, and my learned friend, Mr. Habites Lassie, appears pro bono on behalf of the respondent. Could I just deal with some housekeeping matters?
Indeed,
if I may?
yes.
The court should hopefully have a core and a supplementary bundle and an authorities bundle.
Yes.
One of the judgments in the authorities bundle is unclear, the Schwema Judgement. I've just printed the non-official version, which we can use at the appropriate point. But otherwise, hopefully, the court can read everything that's in the bundle.
I don't think I've got as far as reading, looking at Schwema yet, but anyway, if we get tab 11, is that right?
It is.
It looks just about legible, although
It's a paragraph.
very squashed in at the margin, I mean in the middle of the page.
It's the words are legible, but not the paragraph number.
Oh, I
It
see,
might be
yes.
inconvenient. We could manage, but I haven't.
Well, if you've got a better copy and you could just let us have it at some point, that would be, but no hurry, at some convenient moment.
Thank you, my lord. The key papers are obviously in the core bundle. Could I just mention, and I do apologise if this inconvenienced the court in any way, I should have made this clear on the index. What the court has in the core bundle are documents in chronological order, so the court will have seen that there was a previous judgment of this court,
Yes.
which is at tab 15. And just so that everyone had everything, the court will find my skeleton argument and notes at tabs 12 to 14.
Yes.
But those have now been superseded by the later skeletons. So the main material that the court needs is the Secretary of State's application to intervene, which is at tab 17, my replacement skeleton, which is at tab 19,
Yeah.
written submissions from the advocate to the court, which is at tab 20, a skeleton from my learned friend for the respondent at tab 21, and then HMRC's reply at tab 22.
Thank you. I think I more or less worked that out. Indeed, I've taken out most of those documents into a separate little,
I'm very
little
grateful.
clip.
So with that, can I begin? This is HMRC's appeal against the decision of Judge Jacobs sitting in the upper tribunal. And the central issue is whether the respondent could keep her family benefit, child benefit, when she moved to Spain, despite the fact that the legislation of the United Kingdom was no longer applicable to her under the Social Security co-ordination legislation.
Just before we go on, I mean, you refer to her as the respondent. It is right, is it? This case is no longer anonymised. I mean, she's referred to below as Mrs. Carrington. Is that still the right way to describe her? Yes. Thank you very much. Yeah.
It is. And the court will have seen that her personal position has been fully protected, and that's set out in the first judgment.
Yes. Yes.
So, essentially, the judgment under appeal is at tab 6 of the core bundle, and it's a short judgment, and essentially the reasons for the decision are captured in paragraph 1, which is page 36 of the bundle.
Yes.
The first major part of the decision is that child benefit can be exported under Article 7 of 883.
That's common ground.
Yes, it is. It's essentially what that means in terms of this case, and that is dealt with in more detail by Judge Jacobs. So absolutely right, your ladyship is right. Paragraph 5, child benefit is a family benefit, and that in principle it's an exportable benefit. But what we say is that Article 7 doesn't bite, or it only bites in a very limited way. And Judge Jacobs essentially rejected that argument in paragraph 10.
I mean, would it be right to say that the real crux of this case is the question of the construction of Article 7?
My lord, yes and no, because the secretary of the government submission is that one can't simply look at Article 7 in isolation.
Well, like any question of construction, of course, you have to look at it
Yes.
in context, and I don't mean at all looking at it in blinkers. But ultimately, I think it's common ground, and if not, it seems fairly obvious, that the applicable law changed in 2011 when Mrs. Carrington left this country and emigrated to Spain.
Indeed.
The question is, what is the nature of the retained benefits?
Yes.
Which she had under Article 7. I mean, whether Article 7 applied at all,
Yes.
and if so, with what effect?
Indeed, my lord. And whether it applies subject to Article 59, which would give it a limited application for a short period. But I'll come on to that.
Well, we'll come on to that. I mean, that at the moment strikes me as just a bit of machinery to deal with the week or the month, rather, in which the move takes place. Nothing much more than that. But, of course, we'll come on to that.
Indeed, my lord. So that's the decision of Judge Jacobs.
Yes.
I'm proposing to take matters in 4 parts. So first, to make 3 headline points. Second, to address some general principles of social security coordination and take the court to the key provisions in the legislation, which I say are essentially the context.
Yes.
Third, then to deal specifically with how the system of coordination works for family benefits. And then finally, to make submissions on the grounds, which will be shorter, given that I will have set out all of the context.
Yes. Well, that all sounds absolutely fine. Can I just signal at this stage, I think all of us would find it helpful to have a little general education about how child benefit actually works in this country, because for the purposes of applying Article 7, it may be important to realise what is the nature of an entitlement to child benefit, in what sense it's a kind of accrued right, and in what sense it's more flexible as time goes forward. I'm afraid, speaking for myself anyway, this is not a subject I have much first-hand experience of, so we'll be very reliant on the two of you for any education you can provide us with.
Indeed, my lord. But what I can say is that it's a family benefit. It's not means tested.
Quite appreciate
Or is
that.
it payable to, for example? It's not means tested, but I thought you couldn't get it if the household had income over a certain amount. All those things. Who gets it? Who applies for it?
Could I just turn my back for a moment?
Even who? Do you have to apply for it each year?
Yeah.
Yes, I can certainly get the court the relevant provisions of domestic law over the break, but essentially one gets it if responsible for a child.
I think we would find it helpful, perhaps, just to have a sort of very basic guide to the operation of the system. I don't know where that's most easily found. There must be lots of encyclopedias of social security.
There are indeed.
Probably, and I'm not asking for masses of stuff, because a sort of short, concise guide to the main features, I think, would be useful background.
Just picking up at this stage, you said not means tested, so there isn't even a cap. There's no means testing at all, whatever the family income or individual parents' income.
No, but in response to the question my Lord Justice Lewis raised, technically claimants earning over a certain amount pay a tax charge which corresponds to the amount of the benefit, and that's in the region of £50,000. But it's certainly...
You get the benefit, but you may
You get the benefit, but it has to be paid back through the tax system, or you avoid claiming the benefit in the first place.
Yes.
And do you apply every year for it? I mean, do you have to confirm that you're still responsible for the child, or is it you apply when the child is born and then you get it until the child leaves at 18?
Could I turn my back again for a moment? I do
Please,
apologise.
I think the answer is that you have an ongoing duty to update.
Yeah.
So silence is taken as no change. But I could be wrong about that.
Yeah, so somebody makes an application when the child is born, but then one doesn't have to keep making applications, but to report changes of circumstances. And then it's payable up to age 16, and then the court may have seen in this case that it can be payable for longer in certain circumstances.
Yes.
But it's an application made originally.
And child benefit is administered by the Commissioners of Inland Revenue, is that
It
right?
is,
Or the
yes.
HMRC.
It's an HMRC benefit. And the court will see in the authority fund what we've done and I apologise for not having included the rest of the context, but essentially it's a residence-based benefit in the sense that Section 146.
Yes, we've seen that, yeah. And that residence in this context means habitual residence by virtue of some definition somewhere.
It means, this is in tab 5,
Yeah.
It means ordinarily resident.
Oh, sorry, ordinarily
under
resident.
domestic legislation, which is that the EU test is habitual residence, the domestic test is ordinary residence, but there won't necessarily be any difference in practice between the two. So it's...
And the child and the person claiming it, who may be the mother or the father, have both to be in the United or in Great Britain.
Yes, it's so Section 146. 1 is the child. Section 146(2) is the person who's claiming.
And for some reason, it's Great Britain is the relevant test.
Yes, as with many benefits, there are separate regulations for Northern Ireland.
So when we look at the regulations, you're then treated as not being in Great Britain if you're not ordinarily resident of the United Kingdom.
Yes.
Yes. Well, I can see there's all sorts of byways one can get lost in.
Yes, there's also what's called a right to reside test as well. But that's not something we have to worry
That's
about.
for a separate problem to deal
It's a
with.
separate
EU law.
problem.
Yes.
Yes.
We're not there.
No, my lord, no. Happily, one less problem in this case. So I can certainly, I apologise that we haven't given the court that material, but I can certainly give the court a note overnight if that would be helpful, just so that the court has everything.
Well, I leave it to you, as to how it could most usefully be provided to us, and you might like to have a word with Mr. Abdeslassi about it and decide between you how we can. Thank you.
In that note, if you could just deal with the question of how it can be switched from parent A to parent B, because parent B may leave the house and go and live in France, and parent A may be the one that wasn't getting the child benefit before. Can that parent get it, and how?
Yes, and to some extent that will depend on the operation of the social security coordination rules, which layer on top of domestic legislation because they're regulations, so they're directly applicable. So in that situation will depend perhaps on what the other parent is doing when they go to France, because if that parent goes to France to work, HMRC will say, well, the applicable law has changed to France.
But I'd be interested to know the United Kingdom position. Say they went to live in Japan or the United States.
Yes.
What would happen then? And what the corresponding position is if they go and live in one of the 21 member states, or 27 member states of the European Union.
Yes, my lord, we will do that.
And does it actually have? Is the right to claim the benefit specifically confined to parents, or can it be others who have sort of care and?
But yes, it's not strictly the parents, and again, I can cover that in the note.
Thank you. Right. Well, thank you for that indication of delights in store for us. Perhaps, and I don't want to take part of your course anymore, so if you'd like to revert to where you were, thought you were going.
Yeah, thank you, my lord. Could I just make clear before I get into the meat of my submissions and my 3 headline points that HMRC has accepted that it very much regrets the way that the issues reached this court, and that's why it's made accommodation in this specific case, because certainly the submissions were not as clear as they ought to have been, and HMRC should have pressed for an oral hearing, and it recognises those things, and I can only apologise.
Well, thank you for that. We've obviously noted that, and it's very much to everybody's credit that a sensible way forward was agreed and reached at the earlier hearing before this court. So let's hope that now, at any rate, we have the material we need. I mean, there is, of course, one regrettable hiatus, but nothing can be done about that, and that is the lack of any evidence about the position in Spain.
Yes, and I'll address that when I come to it.
Yes.
Essentially, HMRC is asking this court to address the point of principle, which will depend on whether any of my grounds of appeal are accepted. And then in a future case, obviously HMRC would need to follow the procedure. There are two reasons why we can't say what happened in this case. One, because HMRC didn't know that she'd gone for a couple of years, and second, because it's such an old case that those records aren't available. But HMRC certainly recognises that what needs to be done is prescribed in the legislation, and we will certainly submit that really provides a self-contained solution, which, if it's followed, means that problems won't arise.
Right, thank you.
But I can deal with that discreetly under each ground. So can I then make 3 brief headline points? And the first is this, which is that social security coordination legislation is extremely difficult. It's not just difficult because it's legally difficult, although it is, but it's difficult because one can't just look at a provision in the way one might with a piece of domestic legislation and say, well, let me have a look at that. What does that mean? The words sometimes don't mean what they say.
Not a very good start.
For example, I mean, the court will see that in the example of Tolly. What's an employed person? It's not a person who's currently employed. So that's an example of that. So and one will also see that there are a vast number of decisions of the Court of Justice, which, if one tries to cross-fertilise them across different benefits, aren't always easy to reconcile. So HMRC submit that what one has to do, and the only way one can conduct a proper interpretation, is first to look at the provisions in context, and we submit that requires reading both the main and the implementing regulation as a coherent whole.
Before I forget, is it right they did both come into effect at the same date in 2010, even though they are several years apart?
Yes. So
I mean, that perhaps reinforces the point that
yes,
they should be taken as a coherent.
the coming into force of the main regulation was held up while the implementing regulation was sorted out, and then they both came into force together. So they do work together, and when I take the court to various judgments, the court will see essentially the court grappling with how the different provisions interlock and what they mean when they're read together. The second point I make on that first headline submission is that one also has to look to fundamental principles of social security coordination, and also, and we say crucially in this case, by reference to previous case law of the ECJ in that specific area. And I will need to take the court to some of that case law in detail. It's not the sort of case where I can say a neat proposition and take the court to a neat passage. It's essential that one has to look at these judgments in some detail to understand them, but I'll take that as quickly as I can.
Well, I mean, I absolutely appreciate that, and then of course we'll need to look at the cases, but equally it is important, isn't it, that our starting point must be the 2004 regulation rather than its predecessor.
Yes, although what your Lordship will see is that one of the crucial provisions in the 883 regulation, Article 67, is said by the court essentially to be identical to the same provision in 1408. And so it does mean that the old cases matter. And I would also add, for example, that one of the cases is an 883 case that I have, but one has to look at those older cases, in part because when I come on to my arguments about a purposive construction, I will say that had the legislature really been intending to do what Judge Jacobs decided and the respondent submits, then that would be heralded in a recital, because it is such a departure from the previous position. And 883 says this is all about simplification. Nowhere does it say, and by the way, we're also changing everything for family benefits, everybody watch out.
But Article 7 is different from Article 10.
Right.
Article 10 didn't apply to family benefits, but Article 7 does. And there's nothing in the recitals about that change. There are very often reports as it goes through the European Parliament and Council, but we haven't got any of the underlying materials. Is that because they don't help or because they haven't been looked at?
No, I have looked at the Travo and there is nothing particular. And we can certainly get into the court. It's a fat file like that.
Yes.
But the main the main, and again, we can certainly do that to the call for completeness, perhaps just the introduction by the Commission of the legislation, but it doesn't shed any light on.
What's the answer to the point about the previous legislation not covering child benefit?
The answer to it is that Article 7 must apply subject to all the other bits and pieces of the legislation, and in the context of family benefits, it can be given a very specific construction which makes sense, and it can also be given meaning to the extent that my learned friend's construction is right. HMRC can give it that meaning for the period before the new state takes over, because under domestic legislation, HMRC says, well, we're not paying you because you're not resident here. It can't do that if there's a change of applicable law, because it's got to pay to the end of the month. So either it has the meaning I've given it in my skeleton argument, which is it just means that if you are the state of applicable law, you can't avoid paying simply because the person lives in another state. So let me take an example. If somebody is living in France but working in the UK, so family X, and HMRC is the competent state because somebody is working in the UK. Suppose that the father works in the UK, the mother doesn't work, everybody lives in France. Then the way that it would work is that HMRC's legislation is applicable, and it can't say, well, we're not paying you in France because you're not resident here.
The question is, what happens when he goes back to France?
Well, it depends if French legislation becomes applicable or not. For example, if the person goes back to France as a pensioner or in receipt of a specific type of benefit from the UK under Article 11.2, and I'll show the court that, then the UK's law remains applicable.
But transferred to the facts of this case, the person who comes every day on the Eurostar and works in Dover, or wherever it goes, is French, the family are in France, they can't do in the currency of that employment, not pay him because the children are in France. But if, like this case, they were able to stop working in advance of retirement age and he returned to France, the question then is, would Britain be able to stop paying him because he was no longer resident in France if he had previously been getting child care in France?
Yes, and the answer on the facts of this case, or an analogous case, is that the new state of applicable legislation takes over, and there's no, my primary case is there's no need for any priorities, question of priorities, because the provisions on applicable law in this legislation tell you which state takes responsibility.
And does that apply to disability living allowance as well then?
No,
Does it change for that?
No, because the position is different for sickness benefits, and that I will explain in my submissions. And indeed, I will point to a passage in Tolley in the Advocate General's opinion which supports my position in this case, that family benefits are fundamentally different. And we say, Tolley is a case about sickness benefits, and it's a prime example of the submission I'm making, that the court there simply is not addressing family benefits, and had it done so, it would have had to look at different legislative language, different case law, and that's the submission we make, because the Secretary of State accepts that for sickness benefits, they continue being paid.
Mr. Habdazazi says, of course, there's no principal distinction.
He does, and I say,
will be
yes,
persuade us on that.
Yes, I'll three key reasons why there is a principal distinction.
I mean, on any view, it does, at first blush, look a little odd.
Yes.
We end up with a situation where, if the revenue were right, the DLA paid to Mrs. Carrington's, or in respect of Mrs. Carrington's son, is accepted to be exportable, and presumably is in fact based on cost of living in the UK, or at least conditions in the UK. But it is said child benefit is different.
Yes.
So it's not a very happy looking end result.
Yes, and that precisely brings me back to the first headline point that I was making, is that this is complicated, and one has to look at different benefits differently. I accept entirely that one can take a point and say, well, the position should be the same, and that's the basis upon which Judge Jacobs decided the case. But when one drills down into the case law in my submission, that's simply not right, and there's very good reason for the two being treated differently.
Yes, I mean, to go back to where we sort of started on this excursus, I mean, it just does all, perhaps, well, at least brings me back to the point that the starting point has to be the wording of the 2004 regulation itself, read in the context of its recitals in particular, which emphasize, among other things, the importance of the principle of exportability and the need for derogations from it to be clearly and specifically provided for. And if one does that, it's perhaps difficult to see why Article 7 shouldn't be, given a pretty broad and general interpretation, particularly as it comes in the general section in Title 1, right up front.
Well, I hope by the end of my submissions, your lordship will take a different view.
Precisely. I'm not saying that's a concluded view at all. I'm just, at the moment, that seems to me a pretty obvious starting place.
Yes, the point that I will be addressing later is that exportability and retention of acquired rights are not the same thing. So what one has to look very carefully in my submission at what the legislation says, and that's a point I've made in writing in my reply.
It may be a good idea to prohibit the use of labels, because there's nothing in this that talks about export. That's something that's a loose word that lawyers use. But Article 22 of the old regulation talked about when you could leave the United Kingdom and go to another state, and you couldn't be prevented from taking the benefit with you, and that often became export. But Article 7 is a non-discrimination rule, non-discrimination on grounds of residence, and that may or may not be the same thing. So it's useful not to fall into the trap of treating labels as A, being relevant, or being self-prescriptive.
Indeed, my lord, and I agree entirely, which is why I picked up on the point made by both the advocate and the respondent, who in my submission are conflating two distinct things. One, which is whether a benefit can be exported in principle, because some simply can't. So we were talking about DLA. DLA mobility simply can't be exported. So if a person lives in the United Kingdom, has disability living allowance, the mobility component of it, and moves to France, moves to France but carries on working in the UK, so that UK law is applicable, nonetheless, they can't export the disability living allowance.
Export means nothing to me. What I would want to know is what provision and what principle of law prevents the person from claiming the mobility allowance when he or she has moved. So to say you can't export it tells me nothing. That is the conclusion. It is not the legal reason.
Well,
and that's what I find leaves me in a state of ignorance.
Yes, and I hope again that I will answer your lordship's question by going through the legislation.
Yeah.
So then I really have covered my headline points in answer to the questions. Could I just check my notes?
Yes.
I wouldn't mind the other two.
Just to have a note of them.
The first one was social security coordination is all very difficult. I'm sure we can agree about that.
Yes, I think we can all agree about that. The second point is this, that it's common ground, and this has arisen in questions, that the established position before 883 was that if a person moved to the new state and that state's legislation became applicable, the person needed to claim family benefits from that state. And we submit that the new legislation has clearly preserved that position, and that comes very clearly, we submit, from Article 59 of the implementing legislation, as well as some other provisions. So that's the second headline point, and it feeds into...
Sorry, that was rather a long headline. Could you just repeat in terms I can write down?
In a few words,
yes.
Under the predecessor legislation, if a person moves to a new state and the new state's law becomes applicable to them, it's the new state of applicable law which is responsible for family benefits.
Yeah. And that applies, you say, for the continuation of a child benefit for a child that you've already been claiming for future years, and also a new child who's never been claimed for in the United Kingdom. And
yes.
You say that, and you're going to show us something that says that that is the position, are you, other than Article 58?
Article
59.
Oh, 59.
59, yes, because I'm going to do that by taking the court to the provisions in context by the fundamental principles and by the case law, and I submit that's the only way that one can reach an answer, and if one does that, then my submission is correct.
Yes, well, it was partly, I think, with that line of train of thought in mind that I was anxious we should try and understand a little more about how family benefit works as a matter of domestic law, how far it's right to think of it as a sort of accrued right which you have right until the child is 18, right from the beginning, or how far it's much more something that is sort of fluid and evolves as time goes on.
Well, if you stay here with the child, you will keep getting it.
Yes.
So in that sense, it's paid on the basis of somebody residing here. HMRC's, I'm sorry.
No, exactly. So it's fluid. It is fluid in the sense that if your circumstances change, you're under a duty to notify. And if the change of circumstance means you're no longer eligible, it stops being paid.
Yes.
So as my Lord speaks of accrued rights, perhaps they aren't accrued. Perhaps the right is on a day-to-day or week to week, depending on what the legislation says. It's not an accrued right to anything. It's a right to claim on the basis of the declared circumstances and on providing those circumstances continue. Is that fair?
My lady, I think I would draw on my Lord Justice Lewis' point about terminology, because it rather depends what one means by an accrued right.
Yeah, absolutely.
Certainly in the context of co-ordination legislation, it would be used to describe a benefit which one, to take a simple example, a pension, because one's paid all of the contributions. One obviously can't be deprived of one's pension if one moves. That's a classic example of an accrued right. In terms of domestic legislation, that's certainly not a term that I've accrued right in relation to social security rights. Is not a term I've heard used. So essentially, one has to meet the conditions. So to take a classic case of a family living in this country, they will continue to be able to get child benefit for as long as the children are with them and subject to conditions. But in a straightforward case where a family lives together with children up to age 16, then they will continue being able to get family benefit.
When you say get, even that, you see, triggers a question. The baby is born on the 1st of January 2016. The parents are very excited. They forget all about child benefit because they're taking photographs of the child. Is the first payment triggered when you put in an application? So if the child is 6 months old before you finally fill in the form, you don't get it for the 1st of January to the 30th of June? Or is it something that is payable because a child has come into the world, it is living in the United Kingdom, and the responsible adult is, whether or not some mechanism occurs to cause HMRC to start paying the money?
Yes, and there has to be an application, but there are backdating provisions, so I will check. But I will check, as with all social security benefits, the periods can change, but certainly that's available in principle, and I'll check what the period is.
But on making your first application, the point is you do not accrue an entitlement to child benefit for the next 16 years.
No.
It is a moving target,
Even
depending
though
on your circumstances.
Yes, if you continue to meet the conditions.
Yes.
So,
Although you can backdate it to the date of birth, presumably.
Yes.
Or at least may be subject to some cut-off provision if you leave it for too long.
So to take an example, if children left the country, for example, to go and live with different family members, then there wouldn't be an entitlement. Say, to take the example of USA, if the family think, well, we don't like, perhaps that's a bad example, but we don't like the UK, we'll send our children to live in the States. Perhaps I could have picked a different example. Then
But there may be family reasons, there may be educational reasons.
Indeed,
The mother
and
may be American and they may want to go through the American school system or
Exactly.
the Japanese
Right.
school system.
Yes.
There are lots of good reasons
Exactly.
why a child might not be in the United Kingdom, even if the parents are very happily married.
Exactly. Yes, and in those circumstances there wouldn't be child benefit payable because the children wouldn't be living here. But in terms of the in terms of the way it works, one of the points that HMRC makes is that on the respondent's analysis, the position remains essentially frozen in that even if somebody, so to take a different case, because if Judge Jacobs is right, it will also apply in this situation. Somebody has a child, when the child is sick, they claim child benefit. When the child is 6 months old, that the whole family moves to live in France. And the person is working there, so they're paying into the French system. On the analysis adopted by Judge Jacobs, it doesn't matter. They keep the domestic benefit. They keep the UK benefit ad infinitum.
But yes, and that position would have arisen here had the Carringtons taken up paid work in Spain, presumably.
Yes, that on my learned friend's case, they would keep the UK benefit despite being in a new state of work.
Well, as I understand it, you then have a situation of concurrent entitlements to benefits, and you'd have to look at some kind of tiebreaker provision, because nobody suggests you can get both simultaneously, I don't think.
Well, if that's right, then my lord is with me on ground too. But we say one doesn't get into that position because the French state takes over, because that's the state of work. Yeah. That's the state of applicable legislation, and that really is the architecture of these rules. They start with that.
But the opponent says, of course, that it's the competent state of the state where you've made the application. That is why I was asking you about the application. And if you go to France and it's less money than you would get if you stayed in England, they may say, well, I'm not going to apply in France, and I'd quite like, please, to take the English one with me. You may have the Polish worker who had child benefit in Poland, comes to work in England where it's higher. They go back to Poland and they say, well, excuse me, our child was and did receive child benefit in England between the ages of 6 and 8, and we are entitled to continue that because we haven't applied for Polish benefits, and the competent state is actually the state where the application for the benefit was first made. Yes. And that's why I was asking you about whether or not you actually had to apply for a benefit.
Yes, and the answer to your lordship's point is that my case is that's wrong. That's not how it works. And indeed, I'll point to.
You'll come to that.
I'll point to Tolly, where the Advocate General specifically discusses in a footnote, but it's an important footnote, and says, well, actually, family benefits are different. Yeah. It's not about competent institution. It's about the state of applicable law, and that, in my submission, is a powerful point in relation to the argument that I'm making, because of course Article 7 has to be read subject to other provisions in this legislation, and the primary provision on family benefits, which is Article 67, essentially says it's determined by applicable legislation, and applicable legislation changes. So I will come on to that point. My third headline point is essentially that Article 7 is not a game changer.
What does that mean?
It means that for family benefits, things pretty much continue as they did before, and that if this was a brave new world where now one can keep family benefits from a previous state, that would be heralded in the recitals. There would also be provisions which specifically address what happens where there's an argument between states about who should pay.
Some sort of resolution mechanism?
Yes. So nowhere in the implementing regulation will the court see how to deal with a conflict between Article 7 and the applicable legislation. And the reason in my submission is that because that's not a situation which the legislature envisaged to arise, because the way that it works for family benefits is that when the applicable law changes, competence changes.
So Article 7 is a non-discrimination on residence, and you're saying this is not discrimination on residence, this is differential treatment on the basis of what the applicable legislation is. And there may be some instances where that's residence, there may be other instances where it's not residence, but the factor that causes the change is not residence, you say it's the applicable law has changed.
Exactly.
Is that right?
Exactly, and your lordship will see in the case law that discrimination arguments are raised in cases about family benefits, and the court says, well, it's not discrimination because there's a change of applicable legislation. I wouldn't necessarily accept that Article 7 is an anti-discrimination provision, because the anti-discrimination provision in my submission is in Article 4, which I'll show the court, but what it does do, depending on when it applies, is stop a state which is responsible to pay for refusing to pay on grounds of residence.
And I won't interrupt again, I promise, but for the time being, but can you give me an example of when when Article 7 would work on your analysis in terms of when a responsible state would be stopped from paying on the grounds of residence?
So in the context of family benefits, the example I gave of a family working in the UK but living in France, the UK's legislation is applicable
because of
work in the UK.
Article 11.3a.
Indeed. So it's a bit of a commute, but just to use the example, Article 11.3a means that the UK is responsible for paying family benefits as the state of applicable legislation. What it can't do, and Article 7 does bite, it can't say, we're not paying you because you don't live here.
Understand, thank you.
But you could have a Polish worker working here and only going back to his family once a year for Christmas, and the children are in Poland, and you couldn't stop paying him the money because of the children in Poland. That would be another example, wouldn't it?
An example of somebody working here, yes, while UK legislation is applicable, but one of the point I've taken in my reply is, well, if Judge Jacobs is right, the UK can say, well, you're already getting family benefit from Poland, so you keep that, we're not paying you. Because if one keeps the pre-existing benefit, where does it end? And that's why I submit that my interpretation is the only one which actually works. And although it, on the face of it, one looks and says, oh well, Article 7 says that, that's how it must work. It doesn't in my submission work, and what one can see when one looks at all the provisions why it doesn't work, and that's why it's necessary to examine this in the detail that we are, because it will be a mess, and there's nothing in the implementing regulation or elsewhere which tells you how to sort out the mess. The reason there's nothing in my submission is because things carry on as they always did, and the position was clear, which is state of applicable legislation changes, you look to that new state.
Good. Well, I think after a lot of diversions, we now have your three headlines.
I was certainly expecting, and am expecting, there to be lots of questions, and I hope that I can answer them, and if not, that I can answer them.
Well, I hope you'll forgive us for asking a lot of questions, but it's very much with the aim of trying to see our way towards the right answer, as I'm sure you're all well aware.
Indeed, my lord. There is in my submission no way to deal with this without asking lots of questions. So, of course, the court will continue to ask questions.
Afraid we will, yes.
Indeed. So, could I then get into the second part of my submissions, which is to deal with the key principles of the legislation? And I'll do that first by taking the court to 883/2004 and looking at the key provisions there. And then what I will do is deal with 5 key principles of social security coordination. But perhaps if we start with the legislation, and we've had a head start because the court's questions are absolutely raising the issues which arise when one looks at this legislation. So it's in tab 1, and the court is already aware that this didn't come into force until 987/2009 was in place, and of course we make the point that both regulations are binding in their entirety and directly applicable and must be read together. It isn't that one has a lesser status, they're both regulations. And what we will see in the case law is that the court does give meaning to both. So what I'll do first of all is give the court a bird's eye view, and I won't yet get into the detail of the family benefit provisions until I've dealt with the general principles, if I may. So could I begin with the recitals, tab 1, page 4.
Yes.
So recitals 3 and 4. Recital 3 is important because it's saying what are we doing differently from 1408-71. So could I invite the court to read recital 3?
Yeah.
So it's modernising and simplifying in order to achieve the aim of free movement of persons. And pausing there, the whole point of having this regulation is to facilitate free movement, because without it nobody would know where they stood. Recital 4, it's a system...
Sorry, what do you mean by that?
Because it would be chaos in a sense. This is a conflict of law provision. So if somebody moves to a new state, it tells you which state is responsible for paying them benefits and which state they pay contributions to. So it's essential to facilitate free movement that there is this coordinating
Would they be afraid to
legislation.
move if they might lose the pension they've accrued in one member state,
Yes.
or if they had their child benefit cut off and so on? So everybody, as you say, needs to know what the position would be if they go to work somewhere else.
Indeed, although in response to your Lordship's second point about, well, they'll be afraid to lose their child benefit, what the case law does make clear is that a move is not necessarily neutral. So if somebody is disadvantaged by virtue of the fact that there is a change of applicable law, that is one of the consequences of moving. So the question is the applicable legislation, is the state of applicable legislation responsible to pay? And one of the points I've taken in reply is that one can't say, well, it's not in the interest of free movement to take this away. That is Mrs. Carrington's position. Somebody else might say, well, if I'm stuck with this benefit from the UK, it doesn't work.
So it facilitates free movement by clarifying, modernising, simplifying, giving certainty as to the applicable law.
Yeah.
But it doesn't, you say, it's not designed to facilitate free movement by preserving enhanced or superior benefits in one country over those of another.
Indeed. So
The only way you could achieve that would be by harmonisation, which of course is
exactly.
specifically not what has happened in this area.
Exactly. Essentially, it doesn't insulate somebody from all the consequences of a move. But if one takes the classic example of a pension, supposing I worked here, as I have, for many years, and then moved to Spain for my retirement, it would be quite wrong, having paid into the pension, if the UK could turn around and say, well, you're not having your pension now. So that's the classic example. And the legislation makes specific provision for that. It's different, and we'll see this in the leading textbook on this, it's different though for different types of benefits. We say family benefits aren't like pensions, or sickness benefits. So one of the key differences between this legislation and 1408 is that 1408 applied to categories called employed and self-employed persons, but those words didn't mean what they appear to mean at first blush, see Tolly. The difference with 883 is that it covers economically inactive individuals as well, so it specifically brings those within scope of the co-ordination legislation. That's one of the key differences between these two.
What do we get from recital 4?
Recital 4 is that it's simply coordination, and that was to answer a point that the advocate made in writing, but it wasn't. And then, could I invite the court to look at recitals 13, 14, which are go to this point about keeping things that are required already. Let's call it that. So could I invite the court to read recitals 13 and 14? And then, and I promise I won't keep doing this, but just by way of comparison, could I ask the court to keep a hand in page 5 and then turn into tab 3 at page 171, which is the recitals for 1408. And the court will see that, save for a reference to workers rather than persons, 1408 makes very similar provision for acquired rights.
Sorry, where do we find that? Unfortunately, the recitals aren't numbered.
They're not numbered, no, I'm so sorry. It's
4 from the bottom.
by the bottom hole punch, yes. Whereas the provisions for coordination must guarantee
Oh, there we are.
that.
Thank you.
Whereas these objectives must be attained in particular. So the same recitals were in 1408 without that legislation requiring that somebody should keep family benefits when they move state. Could I make a point here about...
Sorry, just before we go on, must guarantee persons moving retain their rights. Is there any magic or anything we get from the words in the course of being acquired?
Well, a classic example would be a pension. So if
Oh,
somebody
right,
works in different states, they might have a bit of pension from Belgium, a bit of pension from France, a bit of pension from Spain. So they would be in the course of acquiring, but they haven't yet reached retirement age when they leave.
I mean, could it be said by a very, very broad sort of analogy, with a child benefit, you're in the sense, you can apply a similar analysis and say it's something that's presumptively going to continue until the child is 16, subject, or maybe even a bit older, depending on circumstances, and that by virtue of having had the child and got your initial entitlement in the UK, that is an advantage which is in the course of being acquired for the purposes of the article.
No, in my submission, because it's a benefit which changes with applicable law, and I'll explain why on a purposive analysis. But one of the points I would make in response to that is that how does that work? Simply by virtue of having had a child in one member state and perhaps only having been there for 6 months, one is then fixed with the benefit from that state, even if it's entirely inappropriate, subject to the point that one chooses not to be subject to that legislation, which I submit is simply impossible as a matter of law, but it simply doesn't work in my submission. It's what if one has another child? Who pays for that? Is one
Doesn't matter, that's a separate thing.
Yes, but in my submission it explains why the position taken by the respondent simply doesn't work, given the way that this legislation works, that it leaves so many questions unanswered, and that's one of them. So okay, I'll keep the benefit from this child. What happens if I then have 4 more children? Is the UK responsible for those?
If the children have never lived here and the person wasn't under the applicable laws, it wouldn't matter. But if the child does live here and the applicable laws applied, the question is whether in respect of that child, it's a retained right. I can't see the fact that you might have other children at a later stage makes any difference.
And it's simply a point I make in terms of one of the issues. But the point really is that child benefit, having a family, is something that continues, and it isn't like paying into a pension and then moving.
Well, that's the question.
Well, that's the issue. I mean, yes. I mean, from one point of view, it can be viewed almost as a kind of entitlement that arrives with the child, subject to making a claim in due course. It's then backdated to the date of birth, and it presumptively continues until the child grows up, and it's focused on the child in question. So, as my lord has said, future children have to be looked at separately, as and when they arrive. But if you have got the benefit of an application made for child benefit in this country, why should it not continue to apply, bearing in mind, as you yourself accept, that changes of residence won't necessarily be neutral? And if that means that's beneficial, well, so it is. But it will work the other way around. So if a Spanish couple located to this country, presumably the revenue would say to them, well, you must look to your Spanish child benefit.
But it doesn't. That's not what it does. What
Well,
it does is...
Yeah, but they might be wrong. I mean, that's one of the issues.
Yes, but it's certainly not what it does now, and it's certainly not the way it has been done. Anyway, I won't get into.
No, I think the logic of the argument against you is that is what the revenue should be doing, unless I misunderstand it.
That is the logic of the argument against us. We don't accept it's right.
Well, of course we don't. I mean, but
for all the reasons that I'll get into, and perhaps again, I will have answered that point by the end of my submission.
And when you do your domestic legislation, could you also just cover off whether or not you get the amount you get paid may be affected by whether you're the only child? So I'm not sure that it may be that for child 2 and 3 you get paid less because person's already
economies of scale.
Yes, that may be a bad point, but something's ringing a bell. if that could just be confirmed one way or the other, that would be helpful. Thank you.
So that was recitals 13 and 14. Then recital 15 is what I call the one applicable legislation principle.
Yes.
Recital 16, there's no justification for making social security rights dependent on the place of residence. Nevertheless, in specific cases. So this is heralding the distinction between two different types of benefits. Social security benefits, and then a hybrid type of benefit called special non-contributory benefits. So I gave the court earlier an example of DLA mobility component. That benefit is not exportable in any circumstances, i.e. you can't take it with you even if it's being paid by, even if your applicable law remains the same. So if somebody moves to France but UK legislation continues to apply to them for whatever reason, there are lots of circumstances in which that can happen, then DLA mobility is
Doesn't
not
move.
exportable.
Yeah.
It's a special non-contributory benefit.
It's immobile, in fact.
And the reason is, you're sure, there's a provision in the legislation, is there, that says
Yes.
that benefit, because to say it's not exportable is to do exactly what I said we shouldn't do. It cannot be claimed in France after you've moved to France, because the legislation specifically
Yes.
provides, and there'd be a provision that's...
It's Article
Right.
70,
Right.
and I can take the court to that now. I can take the court to that as we're going through. What Article 74 says is that those benefits are provided exclusively in the member state in which the persons concerned reside, in accordance with its legislation.
Sorry, is that 70 brackets 4?
70 brackets 4.
But 70 sub Article 3 actually makes the point Article 7 shall not apply to the benefits referred. So it rather looks as if they would have applied had they not been taken out, which is a point against you.
It's a point against me only if one isn't differentiating between the situation where the UK's legislation remains applicable and where it doesn't, because the difference between DLA mobility and child benefit is if in the example I gave the family is working in the United Kingdom but living in France, then that benefit can go with them to France because the UK's legislation is applicable. So in that sense it's not a point against me.
So could you repeat what you just
I'll
said?
explain
The
what
point
again.
against
So
A is only against you if...
Let's take this family living in France, but one of the family members is working in the UK, and for simplicity, none of the family members are doing anything other than this one family member. Mr. X is working in the UK, so the UK legislation is applicable. Mr. X receives DLA mobility. He cannot have that in France, and that's Article 70. But he can and will get child benefit in France because the UK legislation is applicable. So in that sense, there is a distinction. Article 7 means you can't take it with you at all, ever, even if the law remains applicable. And on the construction I'm advancing of Article 7 in the context of family benefits, you can take it with you. It is exportable in that sense. You can take it with you, provided the UK's legislation remains applicable, and that's the fundamental difference between a special non-contributory benefit, which you can't take with you, even if UK legislation remains applicable to you.
Right, okay.
Does that make sense?
Yes,
The point of distinction, and we submit that does give meaning to Article 7 in the context of family benefits, and it does differentiate family benefits from a special non-contributory benefit like DLA mobility.
So why is sub Article 3 there at all then?
Because for special non-contributory benefits, you just can't take them with you at all.
Yes, but
And
that's
that's
what
the end
4
of
says.
that.
So why do you need 3?
Let me just turn back. It's simply setting out that Article 7 won't bite because they are paid exclusively in the member state of residence.
Well, I can see that even if it may strictly not be necessary, it's
Makes
helpful to
sense.
have it there because Article 7 is a general provision
Yeah.
in Title 1 which prima facie applies in the absence of express provision to the contrary.
Yes, and
So it's for the avoidance of doubt, if nothing else, in an area of great complexity. It's no harm to have a touch of superfluity sometimes.
And indeed, if it wasn't there, HMRC could say, never have done, but could, or another state could say, well, we don't care if our law's applicable, we're not paying you because you don't live here. And Article 7 makes clear for family benefits that that can't be done. But in reality, some states did try that and the court squashed them and said you can't do that. But it does make that clear for family benefit.
Well, it's an argument the UK has tried running unsuccessfully in the past, isn't it?
Well,
At least I may have got that wrong, but I thought some of the cases I was glancing at, that argument was predictably, perhaps, squashed quite firmly.
in Tolly,
In Tolly,
for
yes.
sickness
Tolly was,
benefits.
yes.
Yes, it was, but not in similar circumstances. No. So that's essentially, we submit, if it helps to flag it now, that one can give three meanings to Article 7. One can say, one, yep, you take it with you, come what may, whether you like it or not. Two, you can take it with you, you can take a family benefit with you, provided that the UK's legislation is applicable.
Your interpretation.
Yes, but the third one is also an interpretation I advance, and it's this, that in circumstances where there's a change of applicable law, and so the mechanics are that you have to pay until the end of the month, Article 7 means that you can't rely on any domestic residence condition to say, well, I'm not paying to the end of the month because you're not living here. Article 7 would mean that that residence condition is disapplied, and in that way, to the extent that it's necessary to give meaning to Article 7 beyond the context of applicable legislation, then it does give meaning to Article 7. So whether it's construction 2 or construction 3, and I accept that construction 3 makes sense because it works then, it gives everything a coherent whole, but it's certainly not construction 1 in my submission.
I mean, as a matter of first impression, it seems perhaps unlikely that a general important provision like Article 7 should have such a micro purpose, so to speak, as your third
Or
interpretation.
yes, conversely, one could submit it's surprising given the way family benefits have worked and including in cases about 883, the way that the court treats family benefits. It would be surprising if a provision which, like Article 7, which can be construed in a number of different ways, had the very game-changing, as I described it, effect intended for by the respondent.
It does seem to come down to the question as to whether or not you are not paying the benefit because the applicable legislation is now different, or whether you are not paying the benefit even though the legislation applicable provides for it because somebody doesn't live here.
Exactly.
That's it, I think.
Yes,
Isn't
exactly.
Yeah.
So carrying on through the recitals, recital 17 is the general principle, which is that the state of work, if there is one, is the applicable legislation. That's to guarantee equality of treatment of workers. 17A makes clear that once the legislation becomes applicable, the conditions for affiliation and entitlement to benefits are defined by the competent state while respecting EU law. So, that, for example, there is a case which the court has in the papers, which is a case about child benefit, where the UK was infracted, I think, for having a right to reside test for child benefit. So if somebody came to the UK would not pay child benefit unless the person had a right to reside, which is a separate area, but just for the point of explaining this, what the court said is, well, actually, one looks to domestic law to set the conditions, and the domestic conditions have to comply with EU law, but the UK's conditions do comply with EU law, therefore that test is lawful. That's the way it works. So one starts with the question which law applies, and then drill down to the next question. Okay, we know which state laws apply. Do its laws domestically comply with EU law? So that's that discrete second question.
The other two things about 17A, looking at it, one, it introduces a new concept, affiliation and entitlement to benefits, which may be a more accurate description than acquired or retained rights. And it also is clear there that the member state, the applicable member state, is also the competent member state at that stage, whereas the respondent says, oh no, it's always the state of the place of application.
And what I will submit, and by reference to the equivalent provision in 1408, which, as I said, the Court of Justice have said is identical to the provision in 883, is that it's very clearly talking about applicable legislation. It uses the language, but we'll see in a moment what sort of language the Court uses when it's talking about applicable legislation. So 18, but in some situations it's necessary to derogate. And then Article 18A, the principle of single applicable legislation, is of great importance and should be enhanced. So far from this legislation saying, actually, never mind single applicable legislation, we're going to have a brave new world where Article 7 lets you keep what you've got, even on a change of applicable legislation. What it's saying is it should be enhanced. And then what it says is that if you get a benefit, that doesn't mean that the state which is paying the benefit is your applicable legislation. So, as I'll explain...
The grant of the benefit alone.
Yes. Yes,
More
exactly.
accurately.
So there are some benefits where if you're getting them and you move, the state who's paying those benefits stays responsible.
Yeah.
So what I'll submit is that shows that the legislature thought about this, thought about when a state paying one lot of benefits should carry on being responsible for all the other benefits. But as a rule, simply because you're paying one benefit doesn't make you responsible.
Again, and this could all be slightly double-edged, can't it? I mean, maybe said against you that the principle of single applicable legislation is indeed reinforced on the respondent's interpretation, because it makes you concentrate on what happened at the date of the application for child benefit at a time when the applicable legislation was that of the UK, and therefore you got your entitlement at that point, and it carries through.
But in my submission, that's not what the principle of one applicable legislation does. It basically says when you move, this is the law that applies to you.
Well, nobody disputes, I think, that after the move in 2011, the law of Spain became the applicable legislation. But I mean, that just leaves the question: what is to happen with the right to child benefit you've already obtained when the UK law was the applicable law?
Yes,
that's why this is a difficult case.
It is a difficult case, and I entirely accept that. Which is yes, which is why I say one has to look to all the clues to answer it, rather than simply saying, "Oh, well, it must be Article 7." And I'm going, I hope, to give the court all the bits of the jigsaw. And I say, when one has all the bits of the jigsaw, there can really only be one answer. Recital 20 is just about sickness benefits. It says insured persons should be afforded protection. I'm going to come on to sickness benefits just to explain why family benefits are different. And then there are two recitals relating to family benefits, 34 and 35.
Maternity and equivalent paternity benefits. We don't need to be interested in that.
No, that maternity and paternity are a different type of benefit regulated in a different chapter of this
Right.
legislation, so happily.
Thank you.
Yes. Sorry, and the ones you were pointing us to next in relation to family benefits
They're
were...
34 and 35.
Thank you.
Well,
Oh, yes.
33's got something
33
about
has,
family.
yes, it does, doesn't it? Yes. Statutory pre-retirement.
There are special rules for family benefits and pensioners.
This is pre-retirement schemes and equal treatment and the possibility of exporting pre-retirement benefits as well as the award of family and healthcare benefits.
I can check which provision of the legislation that is addressing. I don't understand that provision to be specifically about family benefits, but certainly pensioners, and that pension doesn't necessarily mean under this legislation that you're of a particular age.
No.
It's a type of benefit, have special rules for family benefits and indeed other types of benefits.
No, it's just, I mean, it's interesting, it does use the language of exporting and does appear to take it for granted that there is a possibility of exporting family and healthcare benefits.
But there is the I've accepted in my
Yeah.
example
Yes.
that family benefits can be exported.
Yes, but on the face of it, in a recital up front, one would expect that to be a, well, at least one might expect that to be a sort of general statement applying pretty much across the board to
But
family benefits.
Yes, in a sense though, I mean, family benefits are premised on being exportable because
Indeed.
often one will have people in different, working in one state, living in another, and that's what these provisions are aimed at. So as in the example I gave, they can be exported, but that's different.
Well, that's the problem. There are circumstances in which a person has children in another state and may be living in another state, but can take a benefit payable in state A to that other state. And we call that exporting, but then we automatically assume that it covers other things as well, which is a situation that you say applies here, where the link has been cut because you're no longer governed by UK legislation, applicable legislation. And all of this begs the question, really, as to what do you do when you're in that situation and the umbilical cord of applicability has been severed, to put it dramatically.
Yes, exactly. And your Lordship is absolutely right about the danger of using terms. And I'm sure I'll need to be corrected on that again.
Yes, and of course I'd forgotten, when you made that point, that the language of exporting is actually here in the regulation itself. It's here in Regulation 33 and of course very much in Regulation 37, which we'll be coming to.
And it generally means being in one country and getting something from another country. But as my Lord Justice Lewis says, how you get to that point is a different question.
Yes.
So in terms of Recital 37, and this is a point I made in the reply at paragraph 16 and 17, here, when the court uses the term exportability, it's talking about benefits which can be exported versus benefits which can't, which are special non-contributory benefits. So this supports my point that if what exportability means is just whether a benefit can go to another country in principle. DLA mobility can't, family benefit can. But the character of that benefit as an exportable benefit in principle doesn't answer the question about what happens when the applicable law changes. And that's a point I've taken in response to both the respondent and the advocate to the court in writing.
Do you have a specific point on Recital 34?
No, it's just a flag that those are the recitals for family benefits.
I see.
But they summarise the position essentially. So that was
And,
all.
sorry, should we have a look at 35? I mean, this is the overlapping point, isn't it?
Yes,
The need to have a tiebreaker provision.
Yes, and what the court will see in the cases is in some of the classic change of applicable law cases, the court says, well, this isn't about overlapping at all. And my primary case is one doesn't get into overlapping here because
Yep,
there's an
entitlement
answer.
A that stops and then
Yes.
entitlement B that starts.
precisely, and my fallback position on grounds 2 and 3 is, well, if it doesn't, then one has to have some kind of overlapping provision. provision, because otherwise it drives a coach and horses through the legislation. But my primary case is that I'm right on ground one. So we don't need to get into overlapping. So then, just to give a court then a bird's eye view of the legislation. So Title 1, general provisions, definitions are in Article 1. My learned friend makes a point about the definition of competent institution. Can I just flag that for now as opposed to try and answer it? Article 1AQ. But what the court will see, just by glancing at the definition of competent institution, is that it's long and it's capable of applying to a whole range of situations. Because if the court looks at Lim 2, that taken literally could mean that anyone could apply to benefits from any state. The institution from which the person concerned is or would be entitled to benefits if he or she or a member of his family resided in the member state. So anyone anywhere in the EU would be entitled to family benefits if they lived in the UK. But it doesn't. If
the respondent is right.
No, on any analysis, if
Right.
one takes that definition at face value, if a person living in Spain who's never had anything whatsoever to do with the UK resided in the UK, they would be entitled to benefit, but that doesn't make the UK the competent institution. So what one sees, if one looks at each limb of the definition of competent institution, is that it's very broad, it's capable of covering a multitude of scenarios, and it has to be read in a context-specific way. And that will come out of the case law on family benefits in my submission. The definition of family benefit is Article 1Z at the top of page 14.
Yes.
Article 2 is persons covered. Article 4 is the equal treatment provision in terms of nationals. Article 5 is about equal treatment of benefits, income, facts or events, and the court may recall from looking at recitals 13 and 14 that there's a general provision about retaining rights and advantages acquired and in the course of being acquired, but then recital 14 goes on to spell out how that objective is to be achieved, and it says, this is on page 5, the objective of protecting rights and acquired and in the course of being acquired must be attained in particular by aggregating all the periods taken into account and of calculating the amount of benefits and by providing benefits for the various categories of person covered by the regulation. So in other words, it's saying you've got to have aggregation provisions, you've got to have provisions for working out how much benefit somebody gets. A classic example there is pensions, where you get quite complicated formula, and by providing benefits for the various categories of person concerned. Well, there are provisions which do that. So
I'm sorry, which article are you looking at?
I'm so sorry, I'm in Article 5.
My 5, what was my fault?
But at the same time, I'm reading out loud from Recital 14, and it's
Oh, I see.
I thought it was
point.
Article 6. Is Article 5 or both?
So it's Article 5 and Article 6. So Article 6 is about aggregation.
Which is what specifically referred to Recital 14.
Yes,
Yes.
indeed. And then Article 5, equal treatment of benefits, income, facts or events. So I can give an example under Article 5A. How does that work? It says, where under the legislation of the competent member state the receipt of social security benefits and other income has certain legal effects, the relevant provisions shall also apply to the receipt of equivalent benefits acquired under the legislation of another state. So to give an example here, carers allowance. To qualify for carers allowance, somebody has to be caring under domestic law for a person in receipt of DLA or personal independence payment. But applying Article 5A, the Department for Work and Pensions accepts that equivalent benefits received from other member states also count. So if somebody comes to the UK to work, say, and their elderly family member joins them, receiving, say, a disability benefit from Poland, if that benefit is equivalent, the UK will say, okay, we will treat that as an equivalent benefit and disapply the relevant condition of domestic legislation so that you can qualify for carer's allowance, just to give the court an illustration of how that works. And then Article 7 is, of course, waiving of residence rules, and we will come back to that. But if one looks at the wording of it, unless otherwise provided for by this regulation, so it's subject to the rest of the legislation, cash benefits payable under the legislation of one or more member states or under this regulation shall not be subject to any reduction, amendment, suspension, withdrawal or confiscation on account of the fact that the beneficiary resides in a member state other than that in which the institution responsible for providing benefits is situated. And as my Lord Justice Lewis says, is if you're declining to pay, not because the person isn't resident there, but because your law is no longer applicable, does Article 7 bite? And then Article 10 is just a general provision about prevention of overlapping of benefits. So that's all in Title 1.
Well, I'm just looking at something. Cash benefits payable under the legislation of one or more member states. Well, the cash benefit payable here is child benefit. It shall not be subject to any reduction, amendment, suspension, withdrawal on account of the fact that the beneficiary or the member of his family reside in a member state other than the one in which the institution responsible for providing the cash benefits is situated. And the problem we've got here is a circular situation. Cash benefits are payable so long as you reside in the United Kingdom.
Yes, and we submit that they don't reside in a member state other than that in which the institution responsible for providing benefits is situated, because that's Spain, and they live in Spain, because Spain's the applicable legislation. And that's how it works for family benefits. Now, it's different for sickness benefits, and again, when we come on to it, I'll explain to the court how the department's position developed. But the
benefits in the penultimate line must be the cash benefits payable in the first line, isn't it? So, if you're entitled to cash benefits under the legislation of one or more member states, you can't withdraw them because you live in another member state. So that's fine if you're working here and you say, I'm not going to let you have child benefit because your children are in Poland or France. But the problem that I've got is when the cash benefits are payable precisely on the basis of residence under domestic law, then you are withdrawing them when they're not resident.
Well, that is one construction of Article 7, but it's not the only construction, and that's part of my submission, which is for so central a change to be affected in language which is that unclear, which one has to reread and reread and reread to try and understand what it could mean, and clearly my submission is capable of more than one construction.
Well, you're saying it means cash benefits which would be payable under the cash benefits which are payable under the applicable legislation. You've got to put some words in, and you say that's all right in EU law. It's not like English and Welsh law. It's cash benefits, and it's benefits, not accrued rights. Cash benefits payable under the applicable legislation can't be withdrawn on the grounds that you don't reside in the state of the applicable legislation. That's what you're saying it means, is it?
Yes, and the way that I say do that is not by inserting words, but if one looks, unless otherwise provided for by this regulation. So it's a very broad provision, but each benefit in effect has its own body of case law and its own body of rules. So if one looks at the specific rules on family benefits, and if one looks at the case law on family benefits, in that context, the interpretation is that for family benefits, you can't say I'm not going to give it to you if a person's living in a state other than your state, which is the state of applicable law, but you can say that the applicable law has changed. And if I take an example, I'll take the court to a case called Stewart, which was a case involving the UK and the past presence test. But one of the provisions considered in that case, in the case of Stewart, was the predecessor to Article 7, which was Article 10 of 1408. And what the court says is, well, Article 10 of 1408 doesn't just catch taking something away, it also catches acquiring new benefits. So it's even broader than what the wording says, it's actually acquiring new benefits. But if that's right, it means a state, in effect, can remain limitlessly responsible. So if one takes, supposing somebody, my family that moves to France, and they're pregnant when they leave, but the UK's legislation is applicable because Mr. X remains working in the UK, then the UK couldn't say when they apply, well, we're not giving you that benefit, you didn't have the child when you went, and because the UK law would be applicable. But it would be the acquisition of a new benefit from abroad as opposed to taking something with you. And that is clear from the case law of the court that certainly the predecessor to Article 10 covers that situation.
I know that you want, and I'm sure you're right, to go through the construction exercise when you've done everything out, the precise construction exercise, but just to flag up, I would appreciate your views on the relevance, or if any, of the heading, the meaning of waiving of residence' right rules. So just when you get there, I'd be interested to hear.
Well, I'll make a point immediately, if I may, which is that supports my case, and I'm grateful to your ladyship for drawing it to my attention, because it doesn't say keeping a benefit when you move. It talks about waiving.
It assumes an entitlement under the applicable legislation.
It's a waiving of residence rules, which means if your legislation is applicable, you can't say I'm not paying you. But that's what it's about, waiving of residence rules, as opposed to some broader, every benefit you get, you keep ad infinitum when you move. And although, as I accept entirely, that's certainly for sickness benefits, this is the provision that DWP now accepts authorises the continued payment of family benefits, sickness benefits. If one looks specifically at sickness benefits, and I'll explain 3 reasons why it's different. It is different, not least because, unlike family benefits, there are no other provisions in this legislation which tell you otherwise.
The sickness benefits includes the care allowance of DLA, doesn't it?
It includes,
because of Tolly.
Yes, so DLA has 2 components, care and mobility. So yes, bizarrely, the care component is an exportable benefit in the sense it's not special non-contributory, but the mobility allowance is not exportable.
And we know, do we, that if somebody who has received DLA for the last 5 or 6 years in England and moves to Spain and never intends to come back here, and even if Spain has its own disability living allowance care component, they are still entitled to claim the care component.
Yes.
So there's got to be a reason to distinguish family benefits from the care component of the sickness allowance, because that looks like exactly the same thing.
Yes.
In metaphysical terms. It's a continuing benefit payable reference to a past and future state of affairs.
Yes, indeed, and I accept that entirely, and I've addressed that head on in writing, and I will address it in my submissions because I say there are good reasons. But I need to explain all the pieces of the jigsaw, and then I submit that it makes sense. I'm so sorry. Could I turn my back?
Yes, of course.
That's the problem.
Yes, I'm being reminded, and I should have this at my fingertips because it's a case in which I appeared. It's different for sickness benefits if somebody moves first and then gets sick and wants to claim from the UK. They can't do that. Yes, that's kind of odd.
But it's Mrs. Tolley was in the same position as Mrs. Carrington.
Yes.
Now, Mrs. Tolley was able to go to Spain and continue to receive the care component. But Mrs. Carrington can't receive the child benefit. And I'm still obsessed by why is that?
Well, For a start, that was exactly the position under 1408, as I'll show your lordship in the case law. It was exactly
But
how it worked.
1408 had Article 10 in, which was not applicable to family benefits.
Yes, and but it also had specific provisions for exporting sickness benefits, which
Which is
didn't
Article
exist for
22,
family
yes.
benefits, and that comes back to my point. Then Article 7, the only real argument against me is, well, it's putting family benefits into Article 7 changes everything, and I submit that it doesn't.
But
But that is...
on the face
yes,
of it,
that's
it
the
seems to
crux
me
of it.
it is a powerful point. But I mean, Article 22 was removed, presumably on the view that Article 7, which is a general provision, then governs the position for all articles, including 22, unless otherwise provided by this regulation.
Yes.
And we know from Recital, was it 34, that, you know, one has to look very carefully before you can find anything that encroaches on the principle of exportability.
Yes, and I accept that, and that's why I come back to my first headline point, that if one looks at it from above, it's an obvious and very, very obvious question. But in fact, it can be answered. And in my submission, it's easier to answer that question than it is to explain how, simply on the basis of the language of Article 7, this new regulation has simply dramatically changed the position for family benefits. But I will take the court to a passage in Tolley where the Advocate General says, yeah, under 883 for sickness benefits, it will be Article 7. And in the next paragraph goes on, doesn't expressly deal with family benefits, because that's not what the case was about, but he does say, actually for family benefits it's different, whereas for sickness benefits, the language is competent institution. For family benefits, it's state of applicable legislation. So that will, I hope, make more sense when we get
But
there.
yeah, and he does also make the point, doesn't he? Sorry, we'll come to this, that the reason why the language of Article 20, the old Article 22, is not replicated in 833 is precisely because Article 7 has replaced it.
Yes.
With a more general provision, which makes it unnecessary to put in a specific provision dealing with sickness benefit.
Yes, absolutely. And in my submission, the legislature would have had in mind, doesn't say it's doing anything dramatic, will have had in mind that that's the established position for sickness benefits. But for family benefits, it's okay, don't worry, because we've got Article 67. If anybody had put their mind to this, which in my submission they didn't, because that's not what they thought they were doing. But if anyone had, the answer would be, well, no, it's not going to have that effect for family benefits. See Article 59 of the implementing legislation, see all the old case law, see Article 67. So should I just...
Before you do that, I mean, against labels, you say, oh, sickness benefits, family benefits. Just analyse it. Sickness benefits can refer to a state of affairs where somebody cannot currently work because they're ill, and they get money in lieu of the wages they would have got, and that's something that's often called sickness benefits, and that's specifically dealt with. The disability living allowance care component isn't that kind of benefit, because you could work, I thought, even if you've got the disability care component. So that, whatever you call it, is a social security measure designed to deal with extra costs or difficulties that you've got because of your underlying physical characteristics. Now, on the face of it, once you forget the label, child benefit looks awfully similar. It's money paid because the extra expenses are arising out of your physical characteristics. You've got a child to look after and it needs to be fed, clothed and watered.
There are differences in my submission, and the first point is this, that in Tolley, the Supreme Court was so troubled by the UK's benefits like DLA being treated as sickness benefits, it actually referred the question to the ECJ. And usually under this scheme, sickness benefits are short-term benefits.
Exactly.
So the UK's benefits in that respect are quite unusual, but nonetheless that's how they're categorised, and the UK's stuck with the result of that. But
you say DLA is just a very unusual benefit, and family benefits generally are not like that, and they are dealt with by applicable law.
Sorry, you're just going to make your point on the Tolley point.
I'm so sorry. I can't remember what my point.
In Tolley, the Supreme Court was troubled by DLA treated as sickness benefits.
Yes, so
short term, but
the Supreme Court referred, and the ECJ said no, they are sickness benefits for the reasons it gave in Tolley, but that they're unusual in the scheme of this regulation because they're paid on a long-term basis. So the consequences for the UK of the outcome in Tolley or sickness benefits were more serious than the consequences for other states who tend to pay those benefits on a short-term basis. There is, in my submission, a difference, because what happens with a sickness is a situation arises in the member state which you become sick, and then that risk has materialised. And one of the points the Advocate General makes in his discussion in Tolley is that it's not right for the new state to be fixed with somebody economically inactive in receipt of a disability benefit. So applying a purposive construction, he said, for sickness benefits, that works. Whereas if one compares family benefits, and one's got to remember here that one's looking at a situation which continues for many years, one has children, and on Judge Jacobs' analysis, even if the person moves to another state to work, they still keep the benefit from their old state. And that, in my submission, is very different from the situation of sickness benefits, which is discussed in the Advocate General's opinion in Tolley, where what he says is, well, this is right, actually, because we shouldn't be fixing this new state with the cost of paying sickness benefits to economically inactive individuals. If one has to remember that although this is about Mrs. Carrington's case, the consequences of it are broader, because they would also apply if Mrs. Carrington and her family had gone to Spain to work. And if one does look at it in that way, because one can't, either it moves with applicable legislation or it doesn't. One can't say, oh, only if the applicable legislation in those circumstances. That's not right. So one does, in my submission, and can have to distinguish sickness benefits simply on the basis of that purposive approach before I even get into the provisions in the case law about family benefits, which do say it's all applicable legislation. And there's a passage in Pennings, to which I'll take the court, which says, and that's right, that family benefits are benefits which are very much related to the social context of the payee, because it's the cost of a child. So it's right that those should be paid by the state which is whose law is applicable.
But I'm sure I can make exactly the same point about DLA. I mean, that's surely it's to enable one to defray the costs which arise from disability in one case, or from having young children running around the house in the other.
Yes, but if one takes my broader picture, I mean, in a sense, as well, one has to remember lots of people have children, and that situation continues on for many years, which is why conceptually I said sickness benefits are usually short-term benefits.
Well, I know they are. In fact, the facts of this case bring the problem into high relief, because as a result of obviously pure coincidence, we're dealing with a case where the Carringtons not only are entitled to family benefit, but also have a child who presumably we don't know the nature of his disability, but obviously it's one that entitles him to payment, or did at the relevant time until he reached the age of 18, to payment of disability living allowance. So there we have this single family unit, which raises in acute form what is the real nature of the difference between these two benefits, given they're both capable of lasting for many years into the future, until he reaches his age of majority in each case. And in each case, one would expect them to be geared towards the cost of living and so forth in the UK. So on any purposive approach, it seems bizarre to be distinguishing between them.
Well, in my submission, not, and certainly not according to the Advocate General in Tolley.
Well, best we can. I mean, sure, we have an Advocate's General view, which is obviously useful for what it is, but it's not a decision of the court as such. And
no,
we need to give, obviously, accorded respect, but we're not in any sense bound by it.
And that's why I'm so keen, when we get there, to take the court, the case law on family benefits and the striking decisions of the court, which basically say, yeah, we don't care, even if you want to pay, you can't pay. Too bad, your legislation isn't applicable. It doesn't say that for sickness benefits, it's a different scheme.
You'd seem to want us to carve out family benefits and to ignore the similarities with DLA. That's the problem.
What?
In the face of general wording.
Two points in response. What I'm saying in effect, and I gave those three constructions, is that Article 7 applies differently for family benefits. And second, yes, I am, because yes, one can say there are some similarities, but then there are similarities between all benefits. In my submission, the difference is there are more differences than there are similarities. And when one looks, my submission is not simply that one looks at the benefits. What my submission is that one looks at this legislation. My more powerful point, I would submit, is that one looks at the language of the implementing regulation in Article 67 and interprets the thing as a coherent whole, because otherwise Article 59 in my submission of the implementing regulations is just pointless. So, that in a nutshell, that's my answer for that point.
This is unhelpful, but does disability living allowance vary depending on the gravity of the condition and all the rest of it? Does childcare benefits stay the same per child, irrespective? Subject to my query about the children 2, 3, 4. I think it's the same for each child.
Can I turn my back? Yeah, yes, child benefit is the same.
It's a flat rate, isn't it?
It's a flat rate, but and then it goes down for subsequent children. DLA, I should say, is no more, although there are legacy claimants, but it's been replaced by PIP, personal independence payment, and that is the same in the sense that one gets a certain number of points, and then the amount that one pays depends on the points that one has scored, and that depends on the effect of the condition on the person concerned.
And are you assessed for DLA? Are you assessed regularly? Do you have to self-declare? Is it?
There, as I recall, and I can certainly check this, there is provision for people to be reassessed, but in most cases, as I understand it, those are light touch. Apart from the person would have an obligation if their condition got better or got worse.
To declare.
They would have to
very
say
much.
so.
And again, they can work. I mean, the whole point I thought about PIPs was that it is to encourage people to focus on what they could do rather than what they couldn't. So they're still able to and perhaps expected to work. And they get the PIP as well, just like they got the DLA. So it's not to accommodate for the loss of ability to work. It's for other factors.
Yes, and I should just say that I was one of the various counsel involved as the Tolly litigation played out in the upper tribunal. There was a case before Judge Jacobs about it isn't relevant to this case, but since your lordship has raised the point, it was about whether someone could export their disability benefit, so take it with them under 1408 if they started work in the new state, and Judge Jacobs said that was different. But that's a case about 1408. There's no authority on what happens if somebody starts working. Certainly, the department's position is that you take it with you when you go, and that's that. So, for sickness benefits, that's how it works. But of course, family benefits are much more common and generally payable over a much longer period. Title 2, this is the key provisions. How does one know which legislation applies? And I've said in my reply that the advocate to the court suggested that sometimes it's possible not to have an applicable legislation. In my submission, that's simply wrong. There has to be an applicable legislation. That's how this works. So the rules are set out in Article 11. So Article 11.1, persons to whom this regulation applies shall be subject to the legislation of a single member state only. So the language the court uses, the legislature and the court use when they're talking about legislation being applicable to you, is subject to the legislation of. So the main rules are set out in Article 11.3, but could I just invite the court to look at Article 11.2? What this does is give protection to some people who move by keeping the current applicable legislation that's expressed very badly. What it does is say that if you're receiving benefits because or as a consequence of your activity as an employed or self-employed person, you will be considered to be pursuing the said activity. So what that means is you're treated by virtue of receiving those benefits as if you are still working, and that will mean that the state who's paying those benefits, its legislation continues to be applicable to you. So domestically, and I'm sorry, my DWP lawyer was unwell and had to leave, but my understanding is that employment and support allowance contributory is treated as a benefit which a person is receiving in consequence of their activity as an employed or self-employed person. So that person, the UK's legislation remains applicable to them even if they move, because they are treated as if they are working in that state.
And why is that important to us?
It's important because what it shows is that the legislator did have in mind protecting people when they move by keeping legislation applicable to them, because that is a way of ensuring that the person remains subject to the legislation of their last state. So in that situation, there'd be no question of them getting family benefits. So in my example of Mr. X working in the UK and the family moves to France, assume that he has an award of employment and support allowance contributory. He, whether or not he's working, in fact, he's still subject to the legislation of the UK, and he will get his family benefits, no issue.
So I work in England, I lose my job, I go and try and find another job in France as a barge hand. I can take my, what I would have called job seekers allowance, or the ESA, whatever it is now. with me. I can't answer that for the
job
applicable
seekers
legislation is the thing that determines whether or not I qualify for ESA is English law, not French law. That's what you're saying.
What I'm saying is, and I may not have explained this, I suspect, what this provision does. Can I come back to Article 11.2? Because what it does is treat somebody as if they're a worker, even if they're not.
Yeah, and I thought that was the job seeker, effectively. No.
If you're getting a financial benefit from a job you've left in England,
Yeah.
of some sort, so you've left the employment, but you are getting some sort, you're allowed to keep the car for an extra year, even if you stop working, or a pension benefit, but you're not working in England anymore, you're working and living in France, you still are entitled.
Could I, the difficulty, the reason I'm hesitating is that there are very special provisions about unemployment benefit in this legislation, and I don't want to lead the court astray.
Also, I mean, the obvious example of benefits within the first sentence is pensions, but they're immediately taken out by the second sentence.
Yes, because there's special rules about pensions, and they're very complicated.
Well, I'm sure they are, but I'm just wondering what's left. You know,
that's why I gave the example of ESA.
Well, what is ESA? Sorry, I mean...
So employment and support allowance.
Employment and support allowance?
Yes, it's a benefit which is payable to people who are have limited capability for work, as I recall. There's a case I did in this court on a separate issue to do with rights to reside, but it does set out what employment and support allowance does, so I can give that to the court by way of background. It's called Al Hashem. But essentially,
yes.
it's a benefit which is paid if you have limited capability for work. So somebody who's getting...
But it's paid because or as a consequence of your work.
That's how it's treated, yes. Because it's contributory, so you will have got it because you've been working and paying contributions by and large. So that, in those circumstances, and I will certainly check this evening.
Yeah, sorry, the car's a bad thing. It's a cash benefit we're looking at.
Yes, receiving cash benefits because of shall be considered to be pursuing the said activity. So that means that... And again, I will certainly check this with DWP because I haven't got anyone sitting behind me, and I apologise, but that's my understanding. If not, I'll give the court another example. But what that does, what this provision is doing is making sure that somebody receiving those benefits is treated as if they are
A worker.
Yes.
So that Article 3A applies, because the first rule is if you're working somewhere, that legislation is going to be applicable to you, and that's Article 11.3A.
But the other thing that immediately gets one obsessed is the last three lines of 2. The people who come out of this are the people that were originally in Article 10 of the first regulation, 1408. And you think, well, they must be doing something with the people who couldn't have things denied to them under Article 10, because the thing that stopped them being able to claim Article 10 has now gone into Article 11 too. Do you follow me? And the
Yes.
question is why? What's that all about?
Yes, and I'm afraid sometimes with this regulation, the questions are not easy
I mean,
to
if I
find
looked at the old
answers
Article
to,
10 on
which is-
page 180, I would have known that except for invalidity, old age and so on, you couldn't refuse it on grounds of residence. And that's why some were, in the jargon, exportable and some were not, because if it was invalidity, you didn't take it with you, but if it was sickness, a la Tolly, you did take it with you. And the very exceptions there, which stopped you being able to say, I want it, now I've moved abroad, aren't in the new regulation at all, say they come back into the definitions in Article 11. And that makes me think, well, there must be a purpose for that.
Can I reflect on that
Yes, yes.
question?
But can you see the concern, or what the point is?
Yes, and this comes back to my point that I made at the beginning, that this is incredibly complicated. And if one tries to understand this legislation and all the bits of it and make sense of it, one can quickly become quite mad because it's I don't wish to be flippant, but it is exceptionally unusual in that respect and unlike any other legislation, because there are lots of cases, there are lots of bits, and one can't read them as they are. And Tolly's a classic example. Employed person, yes, but it doesn't mean you're an employed person. It means something else. So that's why I say one has to do the best ones can, collate all the bits of the jigsaw and reach an answer. But
Would it be fair to say the sort of high-level point you get from this is that one of the techniques by which the previously applicable legislation can, in effect, be continued, if the legislation wants to do that, is by a deeming provision.
Yes.
Which effectively is what it says here. You are deemed to be employed or self-employed, even though you cease to be, for particular purposes.
Precisely, your lordship has put it much better than I could, and that answers the point that the advocate to the court made, which is, well, doesn't make sense that one should pay sickness benefits but not other types of benefits. When the legislature was concerned about making sure one state's remained responsible, it did that by Article 11.2.
Well, or at least that's one way in which it could address that type of issue.
Yes.
Perhaps putting it slightly more,
I accept
more
that.
cautiously.
I accept that, yes. So you then get the rules in Article 11.3, and the key is Article 11.3a and Article 11.3e. So A says a person who is working or self-employed or deemed to be shall be subject to the legislation of that member state. So again, the language of subject to the legislation. And then Article 11.3e, any other person, so it's the fallback category. To answer my Lord Justice Lewis's point about unemployment benefits, Article 11.3c, person receiving...
Oh, yes.
And then Article 11.3e, which is the provision here, any other person shall be subject to the legislation of the member state of residence without prejudice to other provisions of the regulation guaranteeing him/her benefits under the legislation of one or more other member states.
And that looks rather like an express saving for Article 7, doesn't it?
No, in my submission, because... No, in my submission, not on the construction I put of it, because... For example, under 1408, that meant that somebody could get their sickness benefits under Article 22. But...
Well, I know, but we've left that regulation behind. This is a new, I mean, like any new piece of legislation, it has to be interpreted on the whole, as a self-contained code,
yes, although,
not by reference to its predecessors.
No, but in my submission, if one looks at the old Article 13(2)(f), which was the equivalent
That is yeah.
So the case law accepts that the old Article 13.2f is subject to other provisions of the legislation. So in my submission, Article 11.3e is not doing that for Article 7 because it would, if that was what it was doing, then why not do it for Article 11.3a as well?
I'm still trying to puzzle out too. Can we take the example of invalidity? We know from 13.2 that a person in receipt of invalidity benefit is not deemed to be a worker. So that person doesn't get anything under the legislation of the state where they're employed and so on, because they're not a worker. So the person who's going to try and get invalidity benefit will come into E, it seems, because they're not going to fit into any of the others. And it'll be the state of residence where the person who's an invalid is.
Well, yes, but there are then very specific rules, and the same with pensions, about if you're getting invalidity benefits or if you're getting pensions, how you then qualify for other benefits. So, for example, and I'll turn my back and get a nod if this is right, but if somebody's in receipt of a pension, then the UK remains responsible for family benefits, regardless of whether or not its legislation is applicable, because of special provisions.
Well, can we just stick to invalidity so I can show you what bothers me? Invalidity, they're not deemed to be a worker. 11.2. So they don't qualify. The applicable legislation isn't that of state A, B, C or D. The invalidity person is going to be claiming the invalidity benefit from the state of applicable legislation, which is the place where they're resident.
Well,
and then I hold on there, and I look back to Article 10 of the old regulation, and the one thing that didn't happen under the old Article 10 was that you got your invalidity benefit in the new state of, that you'd gone to, you got it in your old state. Because the prohibition on not paying for residence, oh no, you would get it in the new state, wouldn't you, for invalidity benefit?
well, Article 11.2 is talking about people who are already getting a benefit. So it rather depends on whether the person, it rather depends then on the rules about taking an invalidity benefit that you've already got with you to another state. Because it's not about new claims for invalidity benefit. It's about people who've already got it.
Well, I'll have to reflect on it, but at the moment, when I read Article 10 and I saw the qualification Article 10 of the old regulation, which stopped people being able to complain if the benefit had been withdrawn, and I see the same words reappear, but for a different purpose, deciding what is the applicable legislation rather than what is the scope of the prohibition on waiver. And I begin to think, well, they must be trying to achieve the same things unless they're bringing about a different set of affairs. And I just find it very odd, and I just don't understand it.
Yes, could I also reflect on
Yeah,
that point?
but can you see why I think there's a link?
Yes, I suspect, and I don't know what the rules
What
are
the link
on
is, yeah.
invalidity benefits. I've never had to address that. I will certainly ask my clients overnight. I suspect somebody at DWP will know.
Yes, I mean it's difficult. No, we need to have these other scenarios in mind. But there's a danger of losing one's sanity if one goes too deep into too many other scenarios, each of which would require several days' work with a wet towel around one's head, probably, to really fully understand them.
Longer, I would submit, and I'm not sure at the end of that one would emerge completely satisfied.
One ends up having enormous sympathy for whoever had to draft this legislation.
Yes.
It must have been a complete nightmare.
And that's the point. It's coordinating vastly different benefits in vastly different member states.
Indeed.
And that's why one
27
has
of them.
words that aren't easy to interpret.
But I think your headline point is be cautious, because behind every door,
yes,
there's a whole new Pandora's box.
precisely. And certainly there are many of those doors that I haven't opened in my working career, and it's incredibly difficult, and precisely, your ladyship has put that perfectly. Which is why I focus on family benefits. So that's Article 11. I just wanted to highlight for the court, for completeness, that there's Article 13, which special rules for people who are pursuing activities in 2 or more member states. And then Article 16 says...
Sorry, what's the point on Article 13?
Article 13 is simply that where there's a complication of somebody pursuing activities in 2 or more states, the legislature's expressly provided for it. And
you have an evaluative exercise as to where the
yes,
the balance of the weight of it lies.
yes, exactly. And Article 16 provides for specific exceptions to the applicable legislation rules, which supports my point that one can't choose which state's legislation is to apply. That the legislature has expressly set out where there are exceptions so that can be agreed in certain cases, and a person who is receiving a pension may make a request to be exempted from application of the legislation, but otherwise there's simply no choice in it, and I'll take the court to a case in that respect. So that was a bird's eye view of the initial provisions of the legislation. What one then has in Title 3 are special provisions for each type of benefit. And I'll come back specifically to the family benefit provisions in Chapter 8. And then, again, just to navigate, there are provisions in Title 4, which is on page 48, about the Administrative Commission, which is a body set up to deal with disputes. And then there are various...
So where does Title 4 start? My fault.
Page 48.
Page
Thank you.
48.
Thank you.
And various miscellaneous provisions in Title 5.
Oh, yes.
And I've already taken the court to Article 70, which was the provision about special non-contributory benefits.
And Article 76, probably very much needed, is one for cooperation between competent authorities.
Yes, indeed.
Yeah.
So that's that. The court may be pleased to hear I won't go to the implementing legislation until we get to the provisions on family benefits.
It's perhaps just worth noting the entry into force provision in Article 91, which actually says it's not going to come into force until the implementing regulation does so.
Yes, I'm grateful.
Yes.
So yes, and my headline submission is they have to be read as a coherent whole.
And it may not be an accident. It took about 5 years to work out how the implementing regulation was going to work.
Yes, indeed.
Yeah.
So, with that, I'm still in key principles of the legislation. What I wanted to do was highlight 5 key principles of the social security coordination in general. I've addressed this in more detail in my skeleton argument, my first skeleton argument at paragraphs 6 to 21, and then my reply at paragraphs 8 to 18. Some of that is addressing arguments advanced by the advocate that I'm not sure are being advanced by the respondent. So what I'll do, if I may, is just highlight 5 key points. So the first is that, as we've seen, this is a system of coordination, not harmonisation. The second...
Sorry, not too quick, please. Yeah.
The second is that the key thread throughout the regulation and in my submission in the case law, we'll see, is that the principle of one applicable legislation is one of great importance, which should be enhanced. And as we'll see in a moment, it's so significant that it can prevent a state from paying benefits even if it wants to. Now, at that point...
Sorry, just catching up. Yes.
We've provided the court with extracts from what is the lead and indeed the only textbook in this area at tab 26. Unfortunately, a new version is about to come out, but not until November. So could I just take the court to chapter 6 in tab 26, which explains the rules for determining the legislation applicable.
Who is Franz Pennings? Do we know? Is he an academic or?
I'm looking at my learned friend. We've got the book in court, so we can check. Somebody very clever who likes European social security.
Well, it must be
law.
riveting stuff. Oh, yes.
So we've given the court a big chunk of the chapter on the rules for determining the legislation applicable. I've sidelined various parts, and perhaps the court can come back to most of it later. But could I just invite the court?
Sorry, I guess we're boring. Can you just tell me the date of this 6th edition? Do we know?
Yes, it's 2015, I believe, and I'm sorry, we've missed off the date page.
2015.
Thank you.
2015.
Yeah.
Could I just invite the court to look at page 83, the second paragraph down the page?
I'm sorry, I'm not getting the page reference. Page 8.
I'm so sorry, I'm looking at the page of the textbook. It's
I'm so sorry, I got
916,
it.
which
I
is
got
hard
it.
to see. It's in tab 26.
Yes, yes. Yeah.
So this is a book which is deliberately written about 883. It replaced the old book on 1408. Could I just invite the court to read the second paragraph, which begins in respect of some categories of benefits?
Yes.
This is the first of two places where Pennings sets out that family benefits are the responsibility of the state of applicable law. So what this passage does is first explains how it works. The sentence I'm relying on is, thus it is possible that a person receives benefit from one country, e.g. his former state of employment, and is subject to the legislation of another country. Well, the court's seen that means applicable law, e.g. his state of residence, where he has to pay contributions, acquires further benefit rights, and, importantly for my case, and/or is entitled to benefits which are paid only during the period a person is insured, such as family benefits. Now, what insured means there, and it's clear from the context elsewhere, is subject to the legislation of. So what Pennings is saying here is family benefits are paid during the period of insurance, i.e. when a person is subject to the legislation of a particular state. So this supports what I'm saying about this is how it works for family benefits.
Well, I'm not sure, does it really go that far? This is just referring to a possible state of affairs. I mean...
No, it says entitled to benefits which are paid only during the period a person is insured, such as family benefits.
Well, it's just describing a certain category of benefit, isn't it? It's not saying all family benefits are of necessity payable only during a period of insurance.
In my submission, no, it's describing the principle, which is that family benefits are paid
only during the period a person is insured.
Exactly.
I
Yes.
see.
So family benefits is an example of a benefit which is paid only during the period in which a person is insured.
Yes.
Even considering Article 7, though, actually, but I take your point that you're saying he's describing the key principle, which is applicability.
And Article 7 simply can't have the effect contended for, because it drives a coach and horses through this system. The third general principle I highlight is that just the states can't choose to apply their legislation or pay benefits even when they want to, and we'll see that in the case law in a moment, nor can individuals escape the application of a particular legislation just because it's disadvantageous to them. Now that will come out of the cases that we look at on family benefits. But for the courts, just to illustrate the point, although it's a case about pensions, can I just take the court to Van Delft, which is a case at tab 10. So on page 455 of the bundle, paragraph 21 to 25 are the facts. Basically, these were individuals who were getting a pension from the Netherlands but were living elsewhere, and they took out private sickness insurance. The law then changed, and they were then required to make contributions to the Netherlands, and they didn't want to. And the argument that they ran is captured in paragraphs 28 and 29. So what they said, the reference in paragraph 28 to articles 28 and 28A are specific rules about how things work for pensioners. And they're saying, well, we don't have to be subject to those rules, we can choose. And they also said that it's infringing our right to free movement if you make us pay. And then the court captures the question at paragraph 44. They argue at 45, well, we are subject to, in other words, the applicable law is the Netherlands. What happened though is that the pensions rules basically were layered on top of those rules and made. So I'm sorry, I've got that the wrong way round. They argued that they're covered by the legislation of residence, which wasn't the Netherlands, and therefore the Netherlands couldn't get a contribution for them. But on top of the rules in Title 2, there were special rules about pensioners in Title 3, and the court says it's just too bad. You might not want to pay contributions to the Netherlands, but you're stuck with the rules in this legislation. So the key passage is at paragraphs 47 to 49, and then at paragraph 51 onwards.
There are no material distinctions for present purposes by reference to 883.
No, because I say this is a point of principle. It's about particularly paragraph 56, sorry, paragraphs 51 and 52.
Yes.
Yes.
That formulation
Yes.
is repeated over and over again in the cases, including on 883.
Yes.
And then at paragraph 54, where there's a choice, the legislation does so expressly. And then at 56 and 57, the court says, well, you're stuck.
So is the bottom line of this complicated case, they got a pension from Holland, Holland changed the rules, and you had to pay extra costs now than you paid before, and they had to pay those extra costs as well.
Yes, and they didn't want to.
And they didn't want to, well, nobody wants to, so but they had to, yeah.
They didn't want to,
So that's
but
it,
they had to.
basically.
They said,
If you're getting a pension from a state, you've got to pay what that state says you've got to pay.
yeah, because the rules said so,
Yeah.
they had to comply with the rules. And it is,
Because the Dutch rule said so, yes.
the Dutch rules said
Yep.
so, but the pension, the overarching social security coordination rules meant they had to pay because they couldn't elect not to be subject to the social security coordination rules, which is in that sideline passage from paragraph 51 onwards what the court is saying.
So you can't opt out, basically, on
Can't
a
opt out.
unilateral basis.
Yes,
It really
can't
comes
opt
down to
out.
it. Yeah.
I should just note that the court will have seen in the written argument there's an issue about whether you need to make an application for overlapping, but that's a discrete issue. That's specifically about the rules on priority. It's got nothing to do with this, which is about applicable legislation. The principle on applicable legislation is clear, that one can't get out of it.
Yeah.
The fourth and the fifth point, and we've been through, so I'll take this briefly. The fourth point is that one can't guarantee that a move will be neutral. I won't take up time taking the court to it now, but at tab 18, the court has the case of Zyler. And this was a lady who worked in the Netherlands for half a year, and then she complained that she didn't receive the full amount of tax credit, which she said was discriminatory. And this is an authority which establishes that a move will not necessarily be neutral. The key passage is sidelined, but I'd invite the court's attention particularly to paragraph 45. It's at tab 18.
18, I think. Oh, I'm looking at the AG. Sorry.
Oh, yes.
We got this the wrong way around. We all.
In mine, the judgment comes first.
Oh, that's right. Page 757.
Page 757, particularly paragraph 45.
Yes.
And that there are very many cases which say this.
Yeah.
And then the final headline point to make about the principles is a point we've already explored in oral submissions, which is the difference between whether a benefit can be exported at all in principle, that's my DLA mobility example, versus the question of whether one can keep a benefit when one goes to a new state and there's a change of applicable law, which is not the same thing. And we explored that in looking at the difference between DLA mobility and family benefit, where the UK law remains applicable and somebody moves to France. So that's how it all works, and I was then about to move to the third part of my submission, which addresses family benefits specifically. I was going to deal with the legislative provisions first, then the cases which I say illustrate exactly how it works for family benefits, that it all turns on applicable law, and then I was going to get into the grounds, but it will take a little time to go through the case law, because as I'm sure the court has picked up, the judgments are quite complicated, but I'll take it as quickly as I can. I see the time. I was going to start, before I got into the legislation, by just showing the court another passage in Pennings which explains what family benefits are. Would it be helpful to do that now?
I think if we got, my watch may be a bit fast. I make it about 7, only about 10 to 1, is that right?
Yes, we've got time. I wondered how much more your lordship, your ladyship could tolerate me speaking about these things.
Well, no, not at all. It's been, I mean, it's
Gripping.
interesting, gripping, but difficult. And there's a
Yes.
limit to how long one can concentrate on it without.
Indeed, indeed. So if
you can keep going, if you feel able to carry on
certainly
a little
I
bit
can.
longer.
Yes, yes. So could I just then start with Pennings, which explains what family benefits are, and it's tab 26
Yeah.
at page 928 of the bundle, or book page 255, and I would just invite the court to read that sidelined passage.
Yeah.
So it's saying that they're an unusual benefit in that sense, and what is crucial is the actual living standards and domestic situation of the claimant.
Just as family benefits, that's defined somewhere.
There's
I
Article
missed that.
1Z, which I think
That's right. Okay, so it
yes,
covers.
right at the end.
Yeah, thank you.
So that's what they are, and then on the next page there's a passage.
And in English domestic terms, is there a list of them we can find somewhere what kind of family benefits are?
No, I can give the court one. But child
Sorry.
benefit,
Yeah.
child tax credit, and guardian's allowance.
Yeah.
Sorry, what was the others?
Child tax credit and guardian's allowance.
Child tax.
And then the other one is child benefit,
Child benefit
and that's it. Those are the only two types of domestic.
and guardian's allowance.
Yes,
but
so
that's
three.
it.
Three types of family benefits. Thank you.
Child tax credit. Oh, is that what you were explaining to us earlier? No, sorry. What is a child tax credit?
Child tax credit. It's
I mean, very roughly, just in the
yes,
sentence.
it's paid to people who are in work, but also who have responsibility for a child. Again, I can give the court more on that if that would help.
Well, maybe if the note you're kindly supplying to us overnight could just have just a really a single sentence description of what the other
Indeed.
of what the types of family benefit are. That would be.
I'm hoping that my learned friend has kept a careful note of all the things that this note should cover. I'm very grateful.
Well, I can tell you at once we will be very, very tolerant, knowing the difficulty and tedium of what we've asked you to try and do.
So what caught my eyes is the last sentence of the first paragraph, which goes contrary to something discussed earlier, which says, rather than being a sort of a standard set rate nationally for every child, it suggests that it's the relationship between the benefits and the actual living standards and the domestic situation of the claimant is much more relevant than in the case of other benefits.
No, I think that is a reference to the rate at which benefits are set nationally.
I see.
So in
Yeah.
each member state, when it's thinking, okay, this is how much it costs.
Oh, I see. Between states, you mean?
I mean, it's
Between
really making
states.
the obvious
Sorry.
point that the state will set these
Yes, sorry.
benefits at a rate which is suitable for its own
Exactly.
nationals
no, I
and its own
understand.
conditions.
Thank you.
Exactly.
Yeah.
And then the other passage on the next page, which is sidelined,
Yeah.
Yes,
so the,
Article 67.
what that says is that the competent state is determined on the basis in Articles 11 to 16. And when I take the court to Article 67 and Article 73, Article 73 talks about being subject to the legislation of. So Article 67 is assuming that everything hinges on applicable law.
Yeah.
So that will become clear. But again, this is an example, I say, of Penning saying for family benefit, you determine the competent state on the basis of the applicable legislation rules.
Well, this is another use of the deeming technique, isn't it? It's put up as if, this is right.
That may make more sense when I show the court Article 67 and its predecessor and the language that they use and the
Sorry, I'm sorry, I'm looking at Article 67 now.
Yes.
It says a person shall be entitled to family benefits in accordance with the legislation of the competent member state, including for his her family members residing in another member state, as if they were residing in the former.
Yes. So Article 67, its fundamental purpose is that if somebody is, say, working in the UK and living in the UK, but their family are living in another state, that the UK can't say, well, your family members are living here. So
Yes.
they have to be treated
As if they were residing. So this
Yes,
takes me
as
back
if-
to the example my lord was giving earlier of a couple living and resident in the UK who might decide to educate their children abroad or something like that. They, for purposes of child benefit, they are still going to be treated as residing in the UK, is that right?
Can I turn my back?
Yes, of course.
Yes, as long as the children are in the EU, that's right.
Oh, within the
Yes,
EU, sorry,
yes.
yes. Yes, of course, yeah.
So Article 67, although that's what it does, we say that it clearly reflects the basic principle that family benefits are paid by the state of applicable legislation.
And that begs the question of the competent member state
Yes.
again, doesn't it? That's,
Yeah.
I mean,
What does it mean? And
Yes.
my learned friend says, well, it means the state to whom the application was directed, which means one is that the competent state is essentially the first state that has ever
Yes.
paid family
Yes,
benefit.
and of course, brings us back to the starting point. The problem we have here is that there have been, historically, in succession, two different competent states, first the UK and then Spain. And the question is, how far the actions taken in State A continue to, as it were, govern when you move to State B?
Yes.
And that brings on back to the question of, well, what does Article 7, read in its context, really mean?
Yes, and we submit that Article 67 reflects that for family benefits, they are determined. One is entitled to family benefits under the legislation of the state of applicable law,
But
rather than.
how can you get it out of 67 then?
Well-
that may be right. I
Yes.
understand the argument.
Yes.
But I
So-
can't see the words on the page in 67 that mean we could have finished the case by 10:35.
Yes, so could I then invite your lordship to turn at the same time as having a hand in at page 45 to tab 3 and the old regulation,
Yeah.
which is Article 70, tab 3, page 221. So this is the old regulation. This doesn't use the language of competent state. It uses the language of subject to the legislation of a member state. And as I've shown the court, that means the state whose legislation is applicable under Title 2.
Sorry, Article 70 on page 219.
No, I'm sorry, Article 73 on
Oh.
page 221.
So this is about unemployed persons, yeah?
No, this is family benefits. I'm sorry, it's in chapter 7, page 221. One can see this is 14
Oh,
away
okay, I've got
on
it. I'm
family
sorry, yes.
benefits.
73, is it?
Yes, Article 73. It's Article 73, employed or self-employed persons, the members of whose families. So this is the old version of Article 67. And it doesn't use the language of competent state, it uses the language of subject to the legislation of a member state.
And the point you make is?
It's you're entitled to you're entitled to benefits provided for by the legislation of the former state, which is the legislation to which you are subject, i.e. the state whose law is applicable to you.
So an unemployed person who has become fully unemployed.
It's the next one down at the bottom, Article 73, and it's got an 8 next to it.
73, sorry, it's my eyesight then. Employed subject to the legislation shall be entitled.
What does the brackets 8 mean? I mean, some of these article numbers seem rather confusing to me.
I'm not sure if that's to do, because this is a consolidated version, I'm not sure if that's why there's an 8 there.
No, but anyway.
It,
But again, I mean, this
Yes,
seems to
it's-
me to be a specific provision dealing with with a natural question which obviously arises where you have an employed or self-employed person subject to legislation. Therefore, the applicable law is that of state X where they live, and this is just saying they will be entitled to their family benefits effectively regardless of the residence of the other members of the family. That's treating the family as a unit, as one would
Yes.
expect, and deeming them all to be resident in the state of the employed or self-employed person.
yes.
I mean, that seems to me a perfectly natural provision to make, but I'm not really sure it helps in the
Yes,
present context.
Can I answer that in two ways? The first is yes, that is what it does, and it's recognised in the case law that it's important that it does that, because
Yeah.
otherwise states could get out of paying
Sure,
depending on where the children live.
quite understand
But
that.
the point about it is it's an important provision. What it does is premised on applicable legislation. So if Judge Jacobs is right, there's nothing here to cover somebody who's covered by Article 7. So if their children live in a different state, too bad. That's the first point. And the second point in my submission is what it's doing is it's recognising, and it's couched in the language of applicable legislation. So in other words, it's drafted on the basis that entitlement to family benefits is determined by applicable legislation, which is necessarily a thing that changes and not according to the competent institution as defined in Tolley.
But again, I'm at the moment not really seeing how you can press it that far as an argument in support of your construction rather than that of the other side.
It's one of the pieces of the jigsaw.
Well, it's part of the picture, admittedly, yes.
So I'm not getting a difference between Article 73 and Article 67.
There is a difference because Article 67 talks about the competent state rather than the state of applicable legislation. But in a case which the court has called Moser...
So but 73 says what? Subject to the legislation
Yes,
of the member
so
state?
rather an employed or self-employed person subject to the legislation of a member state shall be entitled, in respect to the members residing in another state, to the family benefits provided for by the legislation of the former state, i.e. the state whose legislation applies, the state whose legislation they are subject to. It means the same thing. So that's what Article 73 does. It's premised on the state of applicable legislation paying. Now, it may be said against me, well, Article 67 uses different language. It says competent institution. That means that it must be saying...
Competent member state.
You're fixed with the state which first paid, but there's two answers to that. One, I took the court to the definition of competent institution. It's incredibly broad. And two, and more significantly, there is an ECJ authority which essentially says Article 67 and 73 are the same. And that's the case of Moser,
Yes, that's right.
which the court has at tab 19. And for the court's note, it's paragraph 36. Says it's in essence identical to Article 73. So what I'm saying is, if I'm wrong, then there's a big gap here, and the legislation has stuck a provision in which assumes that people will be getting family benefits according to the state whose law is applicable. But they've made that assumption wrongly, because if Judge Jacobs is right, well, Article 7
So Article
changes
67
it.
and Article 73 are inconsistent. With
in their
the-
language.
in their language.
But what that illustrates.
Sorry, with the result reached by the other tribunal judge.
What I'm submitting is I accept Article 70. Article 73 uses the language of applicable law, and Article 7, which is the new one, uses the language of competent institution. And it's argued against me that what that's saying in Article 67 is it's reflecting that somebody's entitled by virtue of the fact that they've got a benefit already, because competent institution means the state who was responsible when you first applied. That's the point that's made against me. And my answer to that is not what competent institution means in Article 67, and that's made very clear when one looks at the predecessor legislation, which the Court of Justice tells us is exactly the same.
At some stage, if you could write down on half a side of A4, I would just like to know the legislative route. Which article or articles has the result that disability living allowance care component remains the responsibility of the state that first granted it. So I can put that set of regulations, provisions, next to all the ones covering family benefits, and I can see whether there's a specific provision about it, Article 967 million, or whether it's actually Article 7. That's what I'd really like to know.
I'm sorry, but did your Lordship ask for sickness benefits?
No. I don't care what you call it. I want to know if I was a person who received in England or Wales disability living allowance care component, and if I had decided to abandon the Welsh Mountains for Catalonia, and I went to the Catalonian office and I said, I want this money. I don't want them to say, oh, sickness benefits, invalidity benefits. I want to hold up a copy of the relevant articles so I know if it's Article 7 that I'm relying on or whether it's a specific provision. Because the thing that I'm still hung up on is that the nature of the provision for disability living care allowance and the nature of the provision for child benefits are the same. And if, therefore, it is Article 7 that stops them denying me disability living allowance when I go to Spain, I'm troubled then by using that same article, but letting it stop disability, letting it stop child benefits. That's where I'm at, not by calling it, this is how family benefits work, this is how sickness benefits work. Which words of the regulation stop it?
And I can answer that immediately.
Oh, good.
The Secretary of State accepts, following a period of consideration, that it's Article 7.
It's Article 7.
Which permits export for family benefits, and I can take the Court to submissions about that, and I believe the history is set out in the Secretary of State's application to intervene.
Right, I'll have a look at it again, but it is the reason why you can get the disability living care allowance component is Article 7.
Yes, and the history of it is that the Secretary of State first argued that Article 7 was subject to Article 21, but based on what the Advocate General says in Tolley, the Secretary of State...
So I'm looking for something then in the provisions about family benefits that indicates some different result, either in the nature of the family benefits or the nature of the provisions governing it.
And the case law.
And the case law, Okay, that's very, very helpful. Sorry to be so obsessive.
No, not completely understood. And the Court does have, I can give the page references, the submissions that the Secretary of State first made on the issue when it was in the tribunal.
Yeah.
And it's also, I believe, the history is referenced in the submissions to intervene as well.
Well, I think it's now well past 1 o'clock, so I'm sure you're feeling ready for a break, and I think probably we are too. So that's no reflection I hasten to add on all the difficult and interesting material you've been presenting to us. But shall I say 2:10? That will give us a decent break to recover. Thank you very much.
Thank you.
Mislaid my